Perfect.
Things keep changing, and never for the best, at least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day. When things look hazy, cause there's nothing left of 25A. Don't get angry, get mad today. Gonna help you through it all the way.
All right,
It's never
it's too long.
Oh.
We need the short version. We keep forgetting to do that. Thank you once, as always, for Talia Zakari, who wrote our theme song. We really appreciate her sharing her talents with us. And with that, I guess we can begin. We have a great group today.
All right, good afternoon. Yes, someone had mentioned more people are showing to this one. I told them it was worth the blood, sweat, and tears I put into this presentation then. My name is Cassandra Chrisman. Some of you might know me as Cassie. I'm an associate with LOMAD. My friend today is Vicki Bueller, also an associate here with LOMAD. We're going to be presenting for you guys at today's meeting the extra considerations for the special considerations. We are only doing the knee and shoulder because, believe you me, it will take more than an hour probably. So even this is going to be probably a somewhat sped up condensed version of it. All right, let's get started. Okay, we're going to start with chapter 5, which is the upper extremities of the shoulder. Now we're referring to the 2018 impairment guidelines. So if you guys are following along, we're just going to go to chapter 5, and that's the section in which we're going to be reviewing the special considerations to begin with.
And to be specific, go to page 32. That is where the special considerations start.
Thank you, Becky. Okay. So give me just one moment. Okay. So to begin, we're actually going to start from a little bit above the special considerations, because this is actually an extremely important part that leads a lot of doctors to misapplication of the guidelines. As many people are, I'm sure, aware, doctors tend to jump right to range of motion and start taking the flexion and the abduction and adding all of that together. And then they get to the special considerations and they start adding that, and you wind up with a mess when none of that needed to be done, because the first thing you need to do, which is very explicitly stated in the chapter 5.4 guidance, is that you first assess whether or not any special considerations apply. So instead of jumping to the special or to the chart for range of motion deficits, you're actually going to go to the special consideration section. For that section, it is addressed in chapter 5.5. It indicates that the following are special considerations that have enumerated scheduled loss of use values. Other deficits may be added when specified or when no schedule value is provided. However, the maximum scheduled loss of use cannot exceed the value of ankylosis. Now, this is also extremely important as an instruction because, again, it's very frequently misread, it's misapplied, and it actually is the foundation for a lot of our appeals or our arguments, because the board is very strict in the application of this. And I'm going to get into some of the more frequently used special considerations, which we've actually been dealing with a lot recently. But this guidance alone is where doctors already begin to mess up how to apply the special considerations and finding an SLU properly. So we're going to start with special consideration number 1. Special consideration 1 says dislocation of the shoulder may be amenable for a scheduled loss of use evaluation, provided that it has been at least 1 year from corrective surgery or recurrent dislocation and that permanent impairment exists after 1 year. Pre-existent recurrent dislocation of the shoulder calls for an overall schedule and apportionment. So this special consideration, as you can see, does not have an enumerated schedule loss of use rate.
Hey Tom, how's it going?
Did you call me on video?
So what I'm referring to is, I'll actually direct your attention to number 3,
If I did, it was an accident.
where the special consideration gives an enumerated schedule loss of use value of 7.5 to 10%. The special consideration number 1 doesn't have that same enumerated value there. So this special consideration, you would go through the regular range of motion calculations. The only thing pending, or the only thing that's going to differentiate it, is that it has to be 1 year after the corrective surgery or 1 year after the recurrent dislocation. Then obviously if it was pre-existing recurrent dislocation, you would apportion that schedule. The biggest thing to note with this is that it's more of a direction. You are going to go from this special consideration to the range of motion chart. However, whether or not the injury can be scheduled, this is more just giving you a time frame of when the dislocation of the injury or the dislocation of the shoulder can be scheduled. So we move on to special consideration number 2, and I promise you it gets a lot more in depth, but some of these unfortunately are pretty, well, they're not misapplied by a lot of doctors, so there's not a ton of litigation on them, which is good. Special consideration number 2 says fracture of the clavicle may equal 0 to 10% depending on degree of impairment. So this special consideration does give you an enumerated schedule loss of use range, which is the 0 to 10%. Now, the important thing again, and where doctors will mess up, is they will give a 0 to 10% for the special consideration, and then they'll give an extra 20% or whatever for range of motion. You cannot give the additional mobility deficits. This special consideration does not allow you to. It gives you an enumerated schedule loss of use, and there is no indication for you to add for mobility deficits. So as far as the part that says depending on degree of impairment, the degree of impairment is just going to allow you to determine where within that range of 0 to 10 the claimant best fits for the SLU.
And the same thing applies to special consideration 3. As you can see, that is also giving you a set range, 7.5 to 10% loss of use of the arm for acromial clavicle or sternoclavicular separation. And if you look at your screen, that is the picture number 2 below, showing a very out of place collarbone. So again, there's no indication there to add mobility deficits. That locks the doctor in. They can't go above a 10% at most on this. Most doctors will cheerfully ignore that and just start adding deficits for everything under the sun. But again, the board's saying, no, you have to stick to the range we're giving you.
Okay, and the same applies actually again for special consideration 4. However, special consideration 4 does have a couple of additional requirements because it is a different injury, that the doctor can only give this special consideration if the winged scapula, which is what you see on the top, that's actually a picture of someone with a winged scapula. If their winged scapula is due to serratus anterior palsy and or trapezius palsy. So you want to make sure that the winged scapula, and I'm not, I unfortunately, I'm not a medical expert, so I don't know all of the different causes of a winged scapula. However, I do know that the board is very strict in following these guidelines. So just make sure if you are, taking testimony of the doctor or something of that sort, that this is something that you confirm with the doctor. And again, you're given a schedule loss of use range, which is the 15 to 20. The doctor cannot add for mobility deficits for this special consideration.
So Cassie, what happens if to apply? Let's say you've got a fractured clavicle and you've got a sternoclavicle separation. What happens at that point?
Actually, I'm glad that you asked that because it was a question that I recently had myself. The board does actually allow you to add 2 special considerations where 2 special considerations apply. So in that case, if a person has a fracture of the clavicle or with an acromial clavicular separation, the claimant can get up to a 20%. So you would use both of those schedule loss of uses, you would add them together. All right, special consideration number 5.
And this is one we have all seen a lot of times because this is a pretty frequent one.
Yes, so sometimes this is actually buried in an operative report for a right shoulder surgery. So I heavily recommend that when you're given a shoulder surgery report, that you read it line by line to see if there is any indication of resection of the clavicle, because it is a pretty frequent thing, and you make sure that the special consideration is applying for that. So this special consideration, which is different than some of the previous ones, does say that you can add for mobility deficits of the single most notable in relation to functional deficit if present. So not only are you able to get the 10% for the resection of the clavicle, but you also can add for mobility deficits. Granted, it needs to be the single most notable deficit.
And I think that, again, is something a lot of doctors screw up. They say, oh, I can add mobility deficits. Here's a laundry list of mobility deficits. No, you have to stick to the most significant one. And that is certainly something that you're going to want to look for and bring up, because that is something I at least see doctors doing all the time.
Now, there was a case that I came across when researching this special consideration in ways that the board is applying this special consideration. And interestingly, is they found that in a case where the flexion and abduction were equal and the ranges of motion were moderate or higher, the board found that the 10% can still apply. So when I'm referring to the ranges of motion being moderate or higher, I'm referring to the notes section that is under the range of motion table that allows you to add 10% when two ranges of motion are within 10 degrees of one another and they are moderate. The board has found that additional 10% can still be added as well as the deficit. So in the instance of employer Ferrara Brokers building materials, there was a flexion and abduction of 75 degrees. So they were both marked. Therefore, they were both also within 10 degrees of one another. That note applied, and the board found that the 10% could still be added under this special consideration in addition to the SLU for the flexion and abduction. Special consideration number 6. Now, this one I think that you guys will enjoy. Give me one moment. Okay. Now, there have been a number of cases where a doctor will try to apply a special consideration to a partial tear. However, the board has found that the credible opinion is that a partial tear is not the equivalent of a rupture. And I apologize, I actually didn't read you the special consideration, but the special consideration says non-surgical rupture of the long head of the biceps muscle is equal to 10 to 15% loss of use. Rupture at distal point of insertion at the biceps is equal to 20% schedule loss of use of the arm, taking into consideration mobility. And the schedule can vary up to 33 1/3 loss of use of the arm, depending on degree of impairment found. So there's been cases, for instance, the one listed underneath, where the doctors are trying to make synonymous a partial tear and a rupture. The board has found that they are not synonymous terms, they're not the same thing, and you cannot apply special consideration number 6 to a partial tear. Now, I would note, because it becomes relevant in this case law, that a complete tear is the same thing as a rupture.
And the relevant portion there is also a non-surgical rupture, because it turns out, and we had to research this, if you have a partial biceps tendon tear in the shoulder, the surgical approach, or at least one of them, is actually to go in and cut that tendon and therefore create surgically a complete rupture. If you do that, apparently you no longer have symptoms, which is not what I would have thought happened, but that's what everyone says and that's what they do. So if you've got a tenotomy procedure done, which is this procedure where they cut the tendon, now technically you have a complete rupture of this tendon.
Okay, thank you, Vicki. And so I know some of you may be thinking that or recognizing the name of the company below the second bullet point, the Chimores Company. And the reason why that would sound familiar to you is because it was formerly located in Niagara Falls. And since this company was located in Niagara Falls, you may be inclined to assume the claimant in that matter was receiving treatment in the Buffalo, Niagara Falls area. And again, that would be right. Now, I say this to say many of you are also probably familiar with the doctor for who this case law was specifically created. But before I go giving that away, I'll tell you what the doctor is doing and what the board is clearly not impressed by. Vicki, if you could just restate what exactly this doctor is doing to create a special consideration.
Yeah, sure. So again, if you have a partial tear, you've still got a partially connected ligament. What he's doing is he's going in, he's doing the tenotomy, he's completing the rupture and therefore solving the problem, getting rid of the symptoms. So now he has a complete surgical rupture.
The board panel, as I stated earlier, has not been impressed by this, and they have found that the doctor's rationale that the non-surgical partial tear, which resulted in surgical rupture, was not covered by Special Consideration 6 and is contrary to the spirit of the guidelines. Now, I'm using the present tense because the most recent board panel decision from this specific scenario involving the same doctor, the same surgery, and the same rationale was just decided 12 days ago. That doctor is Dr. Tetro. Now, I know many of you are familiar with Dr. Tetro. Dr. Tetro's rationale was not only the reason for the creation of this case law, but this case law has continued to be used against Dr. Tetro on several occasions since, with the most recent board panel decision being only 12 days ago. So this is something that carriers should certainly watch out for because the doctor's not learning. He's continuing to attempt to opine this special consideration where he's creating the rupture during surgery. So there's plenty of cases. There's a case in 2019, 2020, 2021, like I said 2 weeks ago, where Dr. Tetro is continuing to do this. So keep an eye out for any Dr. Tetro surgical reports where he's trying to apply special consideration number 6.
I feel like we should start a betting pool. How many cases is it going to take, specifically aimed at Dr. Tetro, where he loses before he figures out he can't do this? Clearly more than 3.
Yeah, I would not place my bets very high on it, considering it seems that he's actually indicated that he's still unaware that this is a thing. So we're going to move to special consideration number 7. No SLU is awarded for this special consideration. Now, the special consideration says frozen shoulder and adhesive capsulitis with or without surgery if the condition is asymptomatic, gives a scheduled loss of use of the arm. If extremely painful and all modalities of treatment have been exhausted, consider classification after 2 years. So this special consideration does not necessarily tell you what to apply for scheduled loss of use. It's just telling you that the claimant is either going to be awarded a scheduled loss of use under one certain condition of a frozen shoulder or a classification under a different. Now, I did research in case law on this and how it's been misapplied. The board has found that the possibility of undergoing an injection or physical therapy fails to meet the criteria for classification under special consideration number 7. So why this was interesting to me is because there is no distinction between curative and palliative treatment. The special consideration in and of itself just says all modalities of treatment exhausted. There is no curative, there's no palliative, which is something we tend to naturally look for because, as everyone knows, MMI can be reached even if palliative care has not been exhausted. That's not the case with this special consideration. The board's found that they're not even going to consider you for classification if you have not undergone or you may undergo injections or physical therapy, which are both palliative care measures. Special consideration number 8. This schedule is given, or the schedule given is focused on the highest value part of the extremity. In case of a high schedule for one given part of the extremity, calculate first the major use in part involved. For example, amputation of the wrist equals 100% loss of use of the hand, or equals 80% loss of use of the arm. If there are additional deficits at the elbow and or shoulder, add 10% to the 80% loss of use of the arm. And the final schedule would be 90% loss of use of the arm. Now, this has had quite a bit of litigation on this special consideration, because the board has actually taken this and they've extended its application. So the board has found, in the case that's relied on is this third department case, matter of Bell, that it is entirely appropriate and consistent with the board's guidelines to only add 10% of the scheduled loss of use of the shoulder for the elbow permanency, as neither the statute nor the board's guidelines list the elbow as a body part lending itself to a separate scheduled loss of use award. So what that means is that if a claimant has, for an example, underneath a 65% scheduled loss of use of the shoulder and a 60% at the elbow, that claimant is only entitled to an additional 10% on top of the high value of 65% of the shoulder. So he actually only gets a 75% of the arm. Now, you'll frequently have claimants counsel try to misapply that and add together both. That's not the case. That is only the case where neither of the scheduled loss of use are considered to be a high value or a high schedule. Now, you might ask yourself, well, the phrase high schedule is a very subjective phrase, and what a high schedule is to someone, might be different to another. Well, the board panel has actually already ruled on this as well, and they've consistently found that a scheduled loss of use of 50 or over is considered to be a high schedule for this special consideration.
So Cassie, how does Genduso or Covington play into this?
So unsurprisingly, claimants counsel attempted to use this interpretation under Bell to their advantage and argued that the special consideration, the SLU of the elbow and the shoulder, were being interpreted to be cumulative, but separately considered scheduled loss of use sites. And therefore, if a claimant suffered a shoulder injury in a prior accident and an elbow injury in a new accident, the carrier should not take credit against the prior arms. It only considered the shoulder, and the new accident is to the elbow. The board quickly and consistently has rejected that interpretation by claimants counsel, finding that the holding in Bell has nothing to do with whether or not a scheduled loss of use of an extremity in a subsequent case should be reduced by the scheduled loss of use of the same extremity in a prior case. So I know some of you may be aware with Genduso and Covington, they allow the carrier to take credit against a prior scheduled loss of use. And in those cases, they make very clear that an arm is an arm. An arm schedule is an arm schedule, whether or not it is for the shoulder or whether or not it's for the elbow. It's an arm. So, however, as previously stated, claimants counsel saw this as an opportunity because they are saying in this special consideration, or they're attempting to say that the SLU of a shoulder and the SLU of a elbow are two different things that are just added together instead of inclusive of being an arm. They quickly shot it down. And I have not seen a case, I actually seen many cases where they have shot it down very, very quickly after this was attempted, this creative, but it was unsuccessful, and the board has been consistent in that this special consideration in the matter of Bell does not affect those standards.
So special consideration 9 is one you may have run across before. This is for a full or partial shoulder replacement. First off, you're probably going to notice the special consideration actually gives you a timeline for when you can get an SLU. You cannot do an SLU for a partial or full shoulder replacement until it's been a year. That's because you may still have significantly changes in function during the course of that year as they heal from the surgery. So what happens when you hit that year mark? What you do is your IME, or hopefully the claimant's doctor, hit or miss on that one, goes to table 5.5, looks at this chart and uses this chart to assess what the SLU comes out to be. A good outcome, our starting base is going to be a 35%, as you can see. What that is going to have to be is 135 degrees range of motion for flexion or abduction, 1 inch or less of atrophy, and no chronic complications. Chronic complications are things like chronic infections. So not just a one shot, but chronic issue here, revision or recurrent dislocation. If you have, say, a 90-degree flexion or abduction, it's going to drop down to fair, assuming you're hitting all of those criteria. So 90 degrees range of motion, and also 1.5 to 2 inches of atrophy. And then, as you can see, it goes down to poor. It is capped off. The maximum SLU is going to be 80%. And what you do, how you apply the chart, is you start out with a 35% as your baseline for a good outcome. And then say the claimant has 135 degrees range of motion, but has 2 inches of atrophy. You're going to look at the chart, look at atrophy, go down. Okay, I got 2 inches. I add up to 5% for that. Now my total SLU is going to be a 40% SLU. And you do that with whatever you have. So if you had chronic complications, you would add another 10% at most, and now you may be up to a 50%. And that is how you would calculate. It's also an easy way to fact check claimants' doctors and make sure that they are in fact properly breaking this down and giving you an appropriate SLU. You can just look through their exam findings and add it up yourself and see what they've done. Sometimes they pull it off, a lot of the time they don't.
Thank you, Becky. So now I know this is supposed to be a slideshow of just special considerations, but I thought that these were important notes as well. And I say notes lightly because these are actually the notes that are included in the shoulder section right underneath the table for range of motion. Now, those notes, the first one indicates that if a deficit of both flexion, forward elevation, and abduction are documented, the greater of the two deficits must be utilized, not both. However, if the deficit in both ranges of motion are moderate or higher, keywords there, and the measures are within 10 degrees of each other, up to 10% may be added to the overall schedule loss of use, not to exceed ankylosis. So what I had found recently in a 2021 case is that the actual moderate range for the board panel does not begin until you actually have less than a 90-degree or whatever the degree is in that section for moderate. So I had recently had a case where the doctor had found that the claimant had 100 degrees of flexion and had obviously concluded that that was closer to 90 degrees than it was the 135 for mild. So he considered that to be a moderate, and he added this note and added the additional 10%. Well, some case law research on that actually shows that it doesn't matter if they're at 93. It doesn't matter how close you are to the moderate range. You actually have to exceed that number going towards the marked deficit. So it's a clear application. We all love clear applications because it stops us from needing to extrapolate percentages versus degrees. So this is a good, I think that this is a good standard that maybe a lot of people weren't familiar with, because I know that, like I said, a 95-degree deficit to a lot of people would be a moderate deficit. So Now, we also have this one that says, do not add mild deficits of internal and external rotation to avoid cumulative values. May add 10 to 15% for marked deficits of rotation and muscle atrophy not to exceed ankylosis. Again, they're using that phrase of marked deficits. Up top, it was moderate. However, I would apply it the same way, that unless it's more than the marked deficit degree, then it's not a marked deficit. So, but the trick here is that you also have to have muscle atrophy. This is not it's not something they can elect. They can't ignore it. They have to have the muscle atrophy. So a lot of times you'll see doctors give additional SLU for internal and external rotations. However, they don't document any muscle atrophy. Well, guess what? They can't apply this note, and they don't get the extra 10 to 15% from this note. So make sure you're always aware that muscle atrophy needs to also be existent for this note to apply. The third one says mild deficits of adduction equal 7.5 to 10% loss of use of the arm. That one is pretty self-explanatory, as well as mild deficits of posterior extension equals 7.5 to 10% loss of use of the arm. Also kind of self-explanatory. If anyone has any questions, feel free to ask them. So now we're going to go to chapter 7, which is the knee and tibia. Do you have that page number available, Vicki?
Of course I do. Chapter 7 is page 43 for the knee and tibia. That is the special consideration section. We're going to go back up to 7.4 again, which is the same as the shoulder. Again, you have to first go down to see if a special consideration applies. Doctors screw this up all the time. Like Cassie said before, they will go down through all of the great range of motion charts. They'll look at all that. They'll add all that up. Then they hit the special considerations and just start adding those into. Not how they're supposed to do it. Again, similarly to the shoulder, you've got a list of special considerations here. The ones that have enumerated schedule loss of use values, that's what it is. They can't go above that unless the special consideration itself specifically says other deficits can be added. Even then, the maximum schedule loss of use cannot go above the value of the ankylosis. Always something to keep in mind when you're looking at some of these sky-high schedules doctors are giving.
Yeah, I would agree. That's likely the result of adding mobility deficits where not warranted. So I wouldn't even bother going through the range of motion findings yourself to see if the doctor has consistent range of motion findings, because you could jump right from chapter 7.4's direction down to the special considerations and realize none of that matters because they're given a very small range of schedule loss of use and they've exceeded it extensively, thereby discrediting their opinion, and misapplication of the guidelines would be very evident. Okay, so chapter 7.5, special considerations 1 through 4. I apologize, this is actually 1 through 3. The patella or total excision equals 7 or 15% loss of use of the leg. Partial excision equals 7.5. This one does say add for mobility deficits and atrophy of muscles. So this one has the specific indication that many others don't for you to add for the mobility deficit. So here it is warranted. Number 2 says patella fracture with internal fixation equals 7.5 to 10% of the loss of use of the leg. Again, that one doesn't have the indication to add for mobility, so you're restricted to the 7.5 to 10% for a patella fracture. To the right, there's an image of what a patella fracture actually looks like. It's just a fracture of your kneecap, basically. Now, special consideration number 3, recurrent dislocation of patella with or without surgery equals 10 to 15% loss of use of the leg predicated upon the extent of residual impairment. So for this one, again, you're given a specific range, and that range is determined in where the claimant falls within that range is determined upon the extent of his or her residual impairment. Now, it does look like I skipped. I'm going to need to go back to that because slides are out of order. So we're going to go to special considerations 5 through 7. Now, special consideration number 5 says a prepatellar, forgive me if I butchered that, I'm sure Brian's listening, or infrapatellar bursitis equals 0 to 7.5% loss of use of the leg. Again, there's that range given. Rupture of the quadriceps tendon and patellar ligament equals 10 to 15% loss of use of the leg, again with a specified range and no addition of mobility deficits allowed. And then fracture of the tibial plateau equals 10 to 15% of the leg. Again, no additional mobility deficits can be added there. So these ones are pretty straightforward as well. Just one moment. I have to go backwards because, as I had stated, my PowerPoint seemed to get a little bit out of order here. My apologies. All right. Special considerations 8 through 9. Osteochondritis dissecans, and I may butcher that, but be butchered that as well, with or without surgery equals 7.5 to 10% loss of use of the leg, predicated upon the extent of residual impairment. Now, the case law, which I found was interesting in regards to this special consideration, is doctors are commonly trying to apply this special consideration to chondral defect. The board has
not the same thing.
No, the board has found consistently that chondral defect is not osteochondritis dissecans. Vicki, do you want to explain a little bit about what the osteochondritis dissecans is?
So osteochondritis dissecans is essentially where the blood flow to the cartilage under the kneecap gets disrupted and it dies, which sounds frankly horrifying. And as a result of that, you may have and often will have damage to the bone may fracture, the bone may break off. That is what they're talking about. They are not talking about a chondral defect. It is absolutely not the same thing. Dissecans is a very specific thing. And I agree with Cassie. A lot of doctors completely ignore that part and go, oh, defect, here we go. We're going to start adding stuff.
So then the next one for special consideration 9, give me just one moment because I believe I missed a special consideration here. And I just want to make sure that I don't have. Vicki, what was the chondromalacia special consideration?
Chondromalacia is number 9.
Okay. Give me just one moment. Somewhere in here, the numbers got mixed up, so I don't want to confuse anyone.
And it is slide number 5.
Okay. That's why I went backward. Okay, so chondromalacia patella, mild to marked degree, equals 7.5 to 10% loss of use of the leg, depending on the deficits of motion and atrophy of muscles found. Now, I would say that this is easily the most misapplied for the knee. I'm sure a few other attorneys would agree with me on that. Chondromalacia in and of itself seems to be a pretty common finding, but the doctors are continuing to add for mobility deficits. There is ample amount of case law where the board has said, absolutely not. There is no indication for the mobility deficits. You are not adding. So therefore, chondromalacia in and of itself is only worth 7.5 to 10%. So the fact that the claimant has 60% schedule loss of use for range of motion doesn't matter. He's only getting 10%.
And on an interesting fact there, I actually have a rebuttal I'm doing today. You don't necessarily need a doctor to even say there's a 10% loss of use because there's chondromalacia. If you have a medical report that says chondromalacia, you can make the argument, and I know because I won on it, that therefore the special consideration applies and there is only a 10% loss of use of the leg. When I made that argument and won on it, the judge actually noted as part of his decision that he didn't care that the doctor had misapplied the guidelines. His job was to apply them correctly. And if chondromalacia was there, it was an automatic 10%, and that was the end of it.
Thank you, Becky. Also, I have come across some case law that says that this special consideration does not only apply for chondromalacia of the patella. This specific case had chondromalacia of the anteromedial aspect of the lateral tibial plateau, and that was found to be part of the knee as well. So the board actually allowed for the special consideration to apply to that as well. And I did put a picture there on the side for you to refer to. The patella is the kneecap, and then the blue, that's in the middle, the tibial plateau is the top of that bottom bone. So this is something that actually is better for carriers, because now they have case law saying that if we have a chondromalacia in the tibial plateau, we can still apply the special consideration. I would have to say that the special consideration has been working very well in carriers' favors. So it's something I frequently look for first, because a lot of the time it's documented in diagnostic testing, and sometimes it's not documented in a report necessarily. So I'm looking for chondromalacia patella, because I do know that it then limits down to a 10%.
Read your MRIs, because that's where you find it.
Correct. So we already went through this. Moment. And chondromalacia was special consideration 4. I apologize. I labeled it 9, Vicky, and that's where you got it mixed up. That's where you got that from. I had a feeling it was wrong. So we're actually going to go now to the correct special consideration 9, which I didn't go over because I had a feeling it was wrong. Instability of the knee cannot be scheduled unless corrected by surgical reconstruction. If surgery fails and instability persists, which will require the use of a brace, consider classification. Laxity of the ligaments and anteroposterior or lateral medial is given a scheduled loss of use of the leg. Now, this one had some interesting litigation on it, actually, where the doctor had attempted to apply this special consideration because the claimant had a knee condition that he had instability of the knee, but she couldn't have the surgery done because she had heart problems, unrelated heart problems. So although she had this condition which warranted surgical reconstruction, she couldn't have it done to her because of her heart problems. And the board panel had said and made clear that without undergoing the surgical reconstruction of the knee, the instability of the knee cannot be scheduled. So the doctor, unfortunately, although he felt it was proper, and just because she was not able to due to her heart condition, unfortunately, this still doesn't apply. You have to have that surgery. Special consideration number 10 through 12. In non-functional prosthesis of an amputee with residual symptoms and complications such as neuroma, phantom pain, and chronic ulcers, consider classification. So this one, pretty straightforward. It is only telling you whether or not you should consider classification. It doesn't give any schedule loss of use range. It's not something that's telling you to add schedule loss of use. So it's just giving you additional consideration, for lack of better words, when you're dealing with a non-functional prosthesis, to consider classifying that claimant given certain circumstances such as neuroma and phantom pain. Special consideration 11 says recurrent locking of the knee may not be amenable for schedule and should be disposed as a classification. So that's another one. No SLU being provided in this. It's not telling you to add an SLU. It's just giving you direction as to what to do when a claimant has recurrent locking of the knee, and that it should be disposed as a classification. Number 12, tibial shaft fracture healed and no malalignment equals 0 to 10% schedule loss of use of the leg. There's an enumerated range here, so as I'm sure you all get by now, which if you do, that's the intention of how many times I'm repeating this because it is so commonly misapplied. 0 to 10% is the only amount that can be applied to this claimant's leg due to this special consideration for tibial shaft fracture, which was healed with no malalignment. So again, 10% is the max, unless of course, like I indicated earlier, there is another special consideration which applies. You can add those two special considerations together, but you will not be adding mobility deficits.
And special consideration 13 is one we are probably all fairly familiar with. That is a total or partial knee replacement. Some of you, if not all of you, may remember the not so good old days when a total knee was automatically a 50 to 55% SLU. The good thing about this is this drastically revised that and knocked the SLU downward. So similarly to the total shoulder replacement, your baseline now for a total knee is a 35% with a good outcome. You may wind up higher, but again, it's capped out at an 80% max. You start with the 35, and just like with the shoulder, you go through it and look at your findings. What's your flexion? What's your extension? Is there malalignment? Is it stable? Is there a leg length discrepancy? Is there atrophy? Which, side note on that, that has to be measured mid-thigh and then compared to the contralateral side. And are there chronic complications, chronic infections, revision, or recurrent dislocation? You, as you see in the chart, you will be adding additional points for those if they are an issue. So if you've got, say, a 35%, you've got, good range of motion findings, but say you have let's say you have about half an inch of leg length shortening, all right, you may be adding on for that. It's if you have 2 inches of atrophy, you're going to be adding on for that. So again, you're going to have to look at the physical exam findings, go through the chart, see what it says, but it tells us how to do that. That is what doctors should be doing. I say should. I actually have a case we're litigating right now where the claimant had a pre-existing total knee replacement. He fell at work, he broke the prosthesis. We were on the hook for the revision of the total knee replacement surgery. It was before the 2018 impairment guidelines went in. So of course he walked away with a glorious 50% SLU. Well, he fell in his driveway, broke that knee replacement, had to get a new one put in. And his doctor has given 100% SLU. First problem, obviously, is the leg is still attached. 100% supposed to be amputation. Our doctor actually did a good job, went through this chart, broke it down, and basically said, it should be like a 40% because 35% for the fairly decent outcome. And then there is a leg length discrepancy that justified adding another 5%. So we're currently litigating that one, but it was really nice to have this chart and go through and, be able to ask the doctor, did you look at this at all? Which he didn't.
Okay, well, that completes the special considerations for the knee as well as the shoulder. Does anyone have any questions regarding those special considerations? I'm not entirely sure how to even see the chat if there is one. Okay, no questions, it seems, unless I'm missing them. Hannah, are you still here? I can't see where the chat is.
Let's see. If you hover your cursor towards the bottom of your screen,
Okay,
there we are. Do you see the chat option in the middle?
I do see it. Okay, so Samuel Patterson, can we get a copy of the case law that specifies what moderate deficit is? Yes, I can. I can provide that. I can also go back because I did actually cite the case law there for you guys. I will leave that there for a minute so I can look at other questions. Give me one moment.
Cassie, I think though, not everyone has access to the like Westlaw to get all of the cases.
Oh, okay. Okay, that makes sense. Sorry. I apologize to whoever just asked that. I assumed that you'd be able to access it. So Samuel Patterson. Yes, I can send that case law. And then sorry. How long can a claimant use the possibility of future knee surgery to put off a schedule finding and to continue to qualify for temp benefits? Leonard Elliott. So actually, a possible future surgery does not bar the claimant from being found at MMI. There is a bunch of case law on that as well. There has to be some sort of active request, or just the possibility, but no action being taken on having that surgery scheduled is not enough to bar the claimant from being found at MMI. I recently had a case which actually I had taken over after some years of litigation, and 3 times the case was delayed over the course of 2 years to the point where our permanency IME was actually 2 years old because a doctor continued to say the claimant needed surgery and then he would file a defective request. However, it was enough to show action and they kept finding that the claimant was not at MMI. So by the time by the time that I got put on the case and I had seen, and actually the board panel reversed that the judges thankfully no longer a judge right now. The board panel reversed the decision of that judge 3 times in one case. So by the time I had gotten to the case, I was able to effectively argue that there was no existing request for surgery. The claimant's doctor had filed a C4.3 stating the claimant was not at MMI because he wanted to have this surgery done, and literally had indicated that we kept denying it. So that was his reason for the claimant being at MMI. I was able to push the judge a little bit on that issue, and he found that the claimant was at MMI regardless of the doctor indicating that the claimant was a candidate for surgery. So there was no active request. There was a request, but it was improper. So absolutely do not feel like you cannot litigate those claims where future surgery is an issue, because it doesn't prevent them from being found at MMI. Plenty of case law to support that. Now, okay, well, it looks like Brian, thank you, actually answered that right below. Some of these aren't questions and you guys are answering for me, so thank you to my colleagues. Samuel Patterson says we can use the special considerations to help with pre-X under scaling. I would need to I guess I don't understand the question.
Cassie, can I jump in?
Yeah, I understand the apportionment, but I'm just not understanding what the question is.
I think this is actually what we were talking about with that third department case that just came out. I think that's what Mr. Pettison's asking.
Okay, so a third department case had recently come out within the matter of a few weeks that says that the special considerations, even if they applied at that time and they apply it this time, if there's no evidence from that prior injury, you cannot take credit for that prior injury. So for example, I have a case where there is a patellar fracture, which would have been schedulable under the time of that patellar fracture occurring, but also schedulable now for the patellar fracture. The records from that patella fracture have been destroyed because, as we know, doctors' offices sometimes destroy. It was a hospital, destroyed the records after a certain amount of years. The board's position on an issue like that is we are no longer, because there is absolutely no medical, able to take credit for that prior injury, even if, and in this case, the claimant had admitted that it was an injury and that she was seeing a certain doctor. It does not matter. The board has found that you need actual medical evidence from that injury. Now, since this is recent, we're still brainstorming ways to obviously apply that differently and how we can, stretch the medical evidence of that injury previously. But as of right now, that was a recent board panel decision, which unfortunately is not in the carrier's favor, indicating that you cannot apply it without any medical evidence from that prior injury.
But if you did have the prior medical evidence, you could still use the special consideration, right?
Yes, you just need medical evidence from that prior injury. And let's see more. All right, it seems like that is all for questions. What time do we have? We have a couple of minutes here, and because I thought that this was a great thing to bring up, but I didn't know how time was going to be on this. I did want to just mention one more thing that I thought was interesting while doing these guidelines is that there's case law, which I would have never guessed, which says that if you have a condition that is not covered under the guidelines, such as in a case where this specific one had a calf strain, which was permanent, it was causing him permanent impairment. It was a calf strain. So that's not an ankle, that's not a knee. The board has found that you can apply a special consideration to account for something like that is not covered by the guidelines. So in this case, the doctor detailed why he thought that injury of the calf, and there was one of the hamstring that I had also found. They applied it, I believe one was to the rupture of the quadriceps was the hamstring, I believe. And I'm not entirely sure of the other one, but I thought that was also interesting. And I didn't know how we would be on time, so I didn't want to push the issue on that, but that was just an interesting thing that I had found too for anyone's awareness. And other than that, it looks like I now have brought myself to the closing of the LOMAD and Friends. Next month, we do have a Halloween special with my colleagues Shannon and Melanie. They will be doing a Zombie Files episode, so definitely want to tune into that for the Halloween special. Thank you all for attending today. And if anyone has any questions about anything that I have presented today, feel free to email and I'll happily answer your questions. All right.